Good afternoon. Welcome to the annual Frey Lecture in Intellectual Property. I'm David Levy, Dean of the Duke Law School. I think this is our 12th Frey Lecture, and the room couldn't be fuller. This lecture was established by our graduate Kip Frey and his wife Meredith, who are here today. Welcome. Kip has had a great career in law and entrepreneurship and entertainment law as well. And he teaches at the law school and at the Sanford School for Public Policy, and he's one of the leading faculty in our law and entrepreneurship program and new degrees. Thank you, Kip and Meredith. Each year, the Frey Lecture brings a distinguished thinker, scholar, or practitioner to the law school to discuss issues that are related to intellectual property and to innovation. And we are very, very fortunate to have David Nimmer with us here today. Professor James Boyle has the honor of the introduction. Professor Boyle is the William Neal Reynolds Professor at Duke Law School. He's a leader in the study of the public domain. He directs the Duke Law Center of that name. He's a founding director of Creative Commons. His books and articles are path-breaking. They always change the discussion, and they are always freely available on the web. Professor Boyle.
Thank you, David, and thank you, Meredith and Kip. Professor Boyle has a cold, which makes him sound very much like Ingrid Bergman. I just want to be alone. It's truly an honor to introduce David Nimmer. Those of you who are even passingly acquainted with copyright law know that whenever federal courts get a question of copyright law, they turn immediately to Nimmer on copyright, the treatise which bears his name, his and his father's name, and they actually rely on it and generally follow it. For a lot of academics, this idea that judges would actually know what they had said, rely on what they said, even be guided by what they said, is simply unbelievable. Whole careers have been made from being slightingly mentioned in a footnote by Justice Scalia or cited in a string cite by Justice Breyer. To be the Nimmer on copyright is truly a foundational important status and one that he bears lightly. But it's not just as a treatise writer, he's also a great teacher, the teacher of many, many copyright lawyers in the United States and around the world. A scholar of academic articles, I'm going to mention one because it's my favorite. It's an article on the copyrightability of a reconstruction of the Dead Sea Scrolls. You might be saying, even after the Sonny Bono Term Extension Act, I don't think that the Dead Sea Scrolls should be under copyright, but this was an actual reconstruction of the fragments, the literal fragments of a scroll. David writes an article about whether this is copyrightable. For those of you who are not copyright geeks, copyright covers only original creative works of authorship. To the extent this was an accurate reconstruction of a historical document, to what extent was it original or creative? Labor, yes. Creativity? Question mark. And of course, as you can imagine, the professor who had reconstructed it wished to say, this is accurate, this is the real thing I have reconstructed, which of course would bar him completely from getting copyright status. I won't tell you how it comes out. For that, you'll have to read the, I think, 153 pages of David's article. I didn't say he was terse.
That's a good beginning. It's 225.
225, excuse me. 153 is the meat, though. There are more digressions in this article than in Tristram Shandy, I have to say. It is just a magisterial piece of work. And as a lecturer, as you will see, David is inspiring, magisterial, learned, and extremely illuminating. Thank you for coming. Thank you for gracing the Frey Lecture. David Nimmer.
Thank you, Dean Levy, and thank you, Professor Boyle, for that most kind introduction. It's a delight for me to be back here at Duke, see old friends David Lang, Jerry Reichman, and what a pleasure it was to meet Kip Frey, get a chance to talk to Meredith last night. It's delightful, and I thank you for bringing me into the inner circle here. I'm going to be addressing Infringement 2.0, starting off with the internet and the changes it has effected to copyright. We'll begin with copyright entrapment and go through a number of other doctrines until we look at the past as a touchstone for getting into the future. Well, you're all familiar with Internet 1.0. The Napster case doesn't need much explication. Any peer, somebody in North Carolina, could connect with someone, who knows, could be in Calcutta, could be in California, ask for a song, and the lyrics say it's going to be a long, long time, but it's actually a very short time that peer-to-peer established copying. All 9 justices of the U.S. Supreme Court recognized that this is copyright infringement when there is unauthorized copying on a wholesale basis of works of high authorship. And that's going to be some of my theme as we go forward. There should be infringement when those 3 factors are present. When those 3 factors are not present, it's questionable whether there should be infringement. And sometimes the net of infringement has been cast too broadly, which is what I'm calling infringement 2.0. Let's begin with copyright entrapment. We start with a lawyer in Las Vegas, Nevada, named Blake Field. He ginned up a copyright case and asked for a cool $2.5 million from Google. The case was based on his authorship of short stories, but I really should call these minuscule stories because they're something that a 5th grader might write for an English class. They were only written for the sake of filing his copyright infringement lawsuit. He wrote these minuscule stories. He then set the robots.txt file so that it would indeed be cataloged when the Google bot crawled his space. And that's exactly what happened. Google cached his works, namely it made a copy on its server. And then he filed a lawsuit against Google for copying his works, the very works he wrote so that they would be copied by Google. Well, the judge ruled, look, this is something that you ginned up. Perhaps you gave an implied license, or you should be stopped from complaining about this here. And the judge looked to a fair use case. There was a search engine, an early search engine called Alta Vista, which provided thumbnail sketches of photographs that had been lawfully uploaded to the internet. So it's kind of an index of the internet. When that lawsuit was filed by the artist Kelly, the Ninth Circuit decided that those thumbnail sketches with lower resolution were not copyright infringement. It was not a wholesale copying. It was copying perhaps of 10% of the pixels for purposes of indexing. And that ruling also came here into this fair use case. And for that reason, as well, Field lost his case. So he gambled that he would win, but came up with a big goose egg, so his case was dismissed. Now I have to introduce you to Perfect 10. It's a magazine as well as a website in later years that has images of the most beautiful natural women in the world. And by natural women, I do indeed mean naked women. People who subscribe to Perfect 10 were authorized to download copies and perhaps put them on their hard drive, but not to upload copies. So here's an instance of copyright infringement, where when our erstwhile user case was handed down a few years ago, today we go on Facebook, then he went on MySpace, and created an image unlawfully using one of the Perfect 10 natural women. Well, there's the Google bot in action, which crawled his web space and made a copy. So now we have on Google not only the authorized Perfect 10 images, but this particular unauthorized image. So when a user makes a request, that user might come across this copyright infringing image. The question is whether Google should be responsible. When someone does a search for Perfect 10, that person could have many things in mind. Perhaps he's thinking of Nadia Comaneci at the 1976 Olympics, getting the first Perfect 10 score. Perhaps he's thinking of Bo Derek in the movie Ted. Whoops. I guess it was that good. It was that good. He could be trying to locate the seminar that Professor Peter Manel and I gave to federal judges about the Perfect 10 case. I myself did not become aware of the existence of Perfect 10 or Vibe Sorensen until the district court handed down an injunction against Google commanding them for copyright infringement to take down this image. It was subsequently reversed by the Ninth Circuit because Google did not have knowledge what was being searched for. But as soon as I read the district court opinion, I myself got curious. So I logged on to see this image of Vibe Sorensen. But I was forestalled in my efforts because already the next day the image had been taken down. But Google said that if you want to know about this complaint, you can go to chillingeffects.org. Now, there's something a bit underhanded going on here, because Google conveyed to chillingeffects.org, an organization that is perfectly legitimate, that is trying to document the ill effects of the Digital Millennium Copyright Act, not only the complaint, but the actual image that was taken down. And so therefore, the same image that was taken down on Google now became available on chillingeffects.org. But things got much worse than that, as I'm about to illustrate. There have been many cases filed for peer-to-peer sharing of pornography. As you know, peer-to-peer services have moved on. No longer is it Napster and Grokster, moved on to BitTorrent. BitTorrent has a distributed model, so it's not one peer in North Carolina dealing with one peer in California. Instead, the works are divided up. A swarm takes individual pieces and then sends them on. How is BitTorrent used? Well, you can see, I'm trying to get my cursor here, but it's not letting me access it. But in any event, you can see in the bottom, 35% is for film. TV is 14.5%. As a book reader, I'm a bit discouraged. It's a culture matter to see that 0.2% is for books. But the plurality, the largest usage, 35.8%, is indeed for pornography. So we have seen litigation being filed. In this actual case, over 5,000 individuals were targeted. It's been a veritable tsunami of copyright infringement litigation, which of course has filled up the FSUP with numerous bases of challenging the subpoenas that have been issued. But what I want to emphasize at the moment is the social aspects that are going on. Imagine that the man of the family is home when the mailman arrives and he opens up a letter. Well, the letter is from Prenda Law, and it contains the unwelcome news that you have been tagged for unlawful viewing of Big Butt Oil Orgy number 3, to cite one of the very few titles that I can even pronounce publicly. And not only that, but you're welcome to pay $150,000 for the privilege. What's the result? Well, because of embarrassment, many people simply send a check right away. Now, Judge Wright, in my jurisdiction, observed that the federal courts are not cogs in plaintiff's copyright enforcement business model. I agree with that proposition as a normative matter. Federal courts should not be cogs. However, Congress, in its wisdom, has seen fit to confer copyright protection on pornography works. Like it or not, federal courts are cogs in this copyright enforcement business model. The judge went on to say that he did not wish to idly watch what is essentially an extortion scheme, and I'm very sympathetic to that. In fact, I think it's even worse than is being revealed here. Back in the Napster day, Rocket Man was put up on the net without authorization from the copyright owner. Here, in this instance, Malibu Media and like copyright proprietors are seeding the internet with pornography in the hopes that John Doe 1 will download it and John Doe 2 and 3, 4, and 5, and they'll file 10 lawsuits as a result. Indeed, I fear, though I do not have the empirical proof of this, that it might be even worse. Copyright is supposed to provide incentives for the creation of works of authorship. I fear that there is incentive to engage in pornographic filming today for the purpose of uploading it only to file the lawsuits against the individuals who are caught in the net. So this is not unauthorized in the true sense. It's entrapment, it's induced. And I see that as a danger of infringement 2.0. I mentioned the fair use doctrine. Let's go a little more deeply into it. Later on, we're going to emphasize factor 2, but for the moment, I want to talk about factor 3, the amount and substantiality. It used to be an old chestnut that when the defendant copied 100% of the plaintiff's work, there was no fair use defense. Well, there were exceptions to that. Today, as I want to show you, the exceptions have become the rule. There can be fair use when 100% of the plaintiff's work has been copied. And here's the perfect lead-in example. I'm switching from copyright law to patent law. I assure you I know nothing whatsoever about patent law, but it is relevant in the following copyright sense. There are copyrighted articles in journals and textbooks, and those have to be submitted to the patent office when the patentee relies on them for patent art. It's called NPL, non-patent literature. As a result of the copying of that NPL, The textbook publisher and the magazine publisher filed a lawsuit against a patent firm for copying their works and submitting them to the US Patent and Trademark Office. Not only against one firm, but against a second, a third, and a fourth. So these 4 lawsuits were pending in 4 different district courts across the country. As a result, the PTO made a motion to intervene to tell the court this is fair use. It's not copyright infringement to make one copy from the American Journal of Physics or Rapid Communications and Mass Spectrometry, and to submit it to the PTO to truthfully apprise the Patent Office about prior art. The PTO came up with a memorandum in which it explained that it obtains much of its material through licenses, but not everything. And it hastened to add that the PTO does not provide copies of this copyrighted material to the public because of the concern that it could be used and copied for reasons unrelated to patent matters. So if it's simply submitted to the Patent Office, that's fair. If it fosters systematic copying on a wide-scale basis, that is not fair. So this is not wholesale copying in that sense. Here's an illustration of turning in a term paper in high school. This is an actual case which I've dramatized. So a case litigated before the Fourth Circuit concerned copyrighted works, admittedly, term papers submitted by high school students, which were aggregated into the Turnitin service so that they could review it and determine whether another paper was infringing. Was it the result of plagiarism? Several students ginned up a copyright case. They claimed a copyright in their term papers, which is indeed a copyrightable work, and they said, you've copied it into the Turnitin service without our permission. The Fourth Circuit rejected that claim. There was no proof that anyone even read it. It was simply put into the database to do this electronic searching. So this was not an example of copying of work of high authorship, and I approve of the ruling. But let's go to copying of works of high authorship. The Library of Alexandria has been transposed in our modern image to the 20 million books to date that have been copied from the libraries at Harvard, Stanford, University of Michigan, New York Public Library by Google. They've been scanned, and optical character readers have made them available on the Google book search. Snippets are available when the keyword is found to be reviewed by the public without permission of the copyright owner. Resulted in 2 lawsuits being filed in 2005. Full disclosure, I participated in the case, having been retained by Amazon.com to oppose the class action settlement. We did not take a position on the underlying causes of action, but we said it's not appropriate to bind the world through the mechanism of class action and to give Google an advantage over all other competitors such as Amazon. We succeeded in that, but the case went forward. So here we have unauthorized copying of works of high authorship, and in some sense it's wholesale because the entirety of the book is put into the database, but it's put there for the purpose of increasing knowledge, of making these little snippets available to someone whose keyword and context represents a hit. So when Judge Chin resolved the case last year, he ruled in favor of Google based on the cases that I've already illustrated to you, that this is fair use. But to my mind, it's more important than even fair use. Rather than saying that one individual for-profit corporation is allowed to do this, we should look at it in the broader scheme. I agree with the sentiment. Google Books provides significant public benefits. It advances the progress of the arts and science. It's a tremendous breakthrough. Indeed, even the non-display uses, the numbers crunching and determining the evolution of the English language and the French language and the Romanian language themselves are extremely valuable. But it's so important that I'm going to come back to this later in my talk to talk about the purposes of copyright and whether it the litigation might have been properly resolved, but the larger social issue remains. Here's an example of copying, not from Google Books, not for scholarly purposes, for very different purposes. Patrick Carriou was an author who spent 6 years living in Jamaica and gained the trust of the Rastafarian people such that he could produce a gorgeous coffee table book of haunting images. So the book sold for a hefty price. He only made about $1,500 per year for all of his efforts, But nonetheless, it was a worthwhile venture for him. But it doesn't mean that no one was earning money, because here we have appropriation artist Richard Prince in the Gagosian Gallery, who charges more than Patrick Carreau will probably earn in a lifetime for just one canvas. What are these canvases? Well, here's an example of Carreau's Rastafarian work, which, when lozenges and a guitar are added into it, become one of the defendant's works. Here's another example, the image repeated, naked women put in. Yet another example, many more naked women. The image is repeated twice. You kind of have to look for it, kind of like a game of discovering where it is. Did I mention that he likes to have a lot of naked women in his artwork? So there you have the image again. Carreau files a lawsuit against not only the artist, but also the gallery and the fine art publisher of the exhibition catalog. When the case is presented to Judge Batts in the district court, she quotes Prince's testimony that his purpose for taking the art was to get as much fact into my work as possible and reduce the amount of speculation. Namely, the defendant's purpose was the same as the plaintiff's original purpose, a desire to communicate to the viewer core truths about Rastafarians. Prince also testified that he has no interest in the original meaning of the photographs he uses. He said, I don't really have a message. So why did he put the guitar on? He collaged the guitars onto portraits of Rastafarian men. He testified that his message related to the fact that men had become guitar players. That was his message. Well, the district judge ruled against the defendant on all 30 counts, decision as a matter of law for the plaintiff. It was then appealed to the Second Circuit, which summarily reversed as to 25 of the counts. It said, we're going to set aside the testimony, we're going to do our own ocular examination, and we think this is transformation. We think as to 25 of them, this is fair use as a matter of law. So complete whipsaw. Not fair use denied as a matter of law, fair use mandated as a matter of law, except as to 5 of the works. There wasn't anything said in the Second Circuit opinion particularly distinguishing one from the other. So I have a question. Here's on the left is alleged fair use number 1. You see it's repeated both vertically and horizontally. And on the right is fair use number 2, also repeated horizontally. So here's my pop quiz, and there's no such thing as abstaining. The answer is either A, only 1 is fair use, or B, only 2, or C, neither, or D, both. Everybody take out your pencil and write A, B, C, or D. Okay? Now, honesty being demanded, raise your hand very high if you voted A. Okay, a few. Raise your hand very high if you voted B. Okay, well, you people have great wisdom that has denied me, because that's the answer. I don't know why. If it's just putting lozenges on that makes it transformative, lozenges are absent in the image on the right. One of them lacks lozenges, so I don't know why the court ruled this way. That's not enough, though, for me to bring this case to you. I'm not talking about mysteries in fair use and transformation. I'm talking about unauthorized wholesale reproduction of works of high authorship. So why am I illustrating this case? It's because of footnote 3 in the Second Circuit's opinion, which I have reproduced here. Images of Carreau's Yes Rasta photographs appear in the appendix to this opinion, which is loaded onto the Second Circuit's website. So you see on the right live links to everything that I presented to you. I presented to you very faithful, not thumbnail images, perfect digital images of all of Carreau's artwork. Is it because Carreau uploaded them to the internet? No. Is it because Prince uploaded them to the internet and it was held to be fair use? No. It's because the Second Circuit uploaded all of them to the internet. And I contrast that lack of sensitivity with what the Patent and Trademark Office said. Look, it's fine to make a copy for a limited purpose, to get a patent, to file it in the government office, but we're not going to facilitate the wide-scale systematic copying. Why do they rule that way? Well, I'm sorry to say this, but I see that the Second Circuit is mired in the most ancient sensibility. At the outset of courts, a court was simply an adjunct of the royal court. It was there to favor the rich and powerful. That was the first level. The second level, a court existed maybe to do distributed justice. A poor man is suing a rich man, and the judges say, you know, we don't really know about the legality here, but this poor man deserves a break. Okay, already 3,000 years ago in Leviticus 19:15, The commandment comes in, lo tase evel. Don't do injustice in court cases. Do not raise up the face of the poor man, but neither should you magnify the face of the great man. Betzedek tishpotamitecha. Use justice in reaching a result for your fellow man. I fear that the Second Circuit was oblivious to that sensibility because of what they said on page 709 of the opinion. Unlike the poor schmo Carreyrou, who could barely eke out $8,000 for 6 years of work, the defendant has a show in which Jay-Z, Beyonce, Tom Brady, Jonathan Franzen, and Brangelina attend. What better proof could there be of fair use than that? Well, I can't imagine that the Second Circuit would produce a coffee table book of Carreyrou's images, and yet it did the current equivalent. And I quote this work from a millennial writing about copyright and the mysteries of what people do in the context of the internet, including Second Circuit judges. You may remonstrate, but Carreyrou introduced his works into evidence, and so therefore it was perfectly fair for the Second Circuit to reproduce them to the public. Think about it for a minute. Every complaint that is filed in federal court for copyright infringement requires the plaintiff to tender to the court a copy of the work so that the court can evaluate it. If it's an automatic incident of filing a copyright infringement lawsuit that your work will be nationalized and expropriated and presented to the public the way the Second Circuit did, then the entire enterprise of copyright litigation is completely fruitless. So I see here a sad example of unauthorized wholesale copying of a work of high authorship coming from the most unlikely of sources, one of the curiosities we have to deal with. My expectations for how courts rule were entirely shattered in this case. But my expectations have been shattered in 5 separate domains as I see the way copyright law has migrated onto the internet. And those domains are, first, publication; second, access; third, what is law; fourth, standing; and fifth, the puzzle of dematerialization. Now, because of my limited time, I've had to cut out all my slides for the intermediate ones, so I'm going to go to the bookends, which are the most significant ones. Let's start with publication. What is publication? Publication is the distribution of copies. So when you have in your hand a copy of a work, then if it's been made available to you with the permission of the copyright owner, the work has been published. How does somebody publish a work 50 years ago or 100 years ago? It took a significant commercial operation. It wasn't something that was done casually. It's very difficult to do. Same question, how were sound recordings published, whether we're talking about vinyl or audio CDs? Very difficult operation to do. What about publication of movies, making DVDs? Also extremely complicated. There was some video piracy on a small-scale basis in the 1980s, but it took a large commercial endeavor to engage in publication for most of copyright history. How is publication effectuated today? Well, if you have a laptop with a wireless connection, you can post things to your blog, your Facebook, your whatever you want, your website, and pretty soon it's promulgated to more recipients than anything other than the absolute bestseller of 1964. So publication is extremely wide scale. What's the significance of publication? It used to be the be-all and end-all. Federal copyright protection under the 1909 Act applied to published works and only published works. Today, it's much more broad than that. There's the so-called dark matter of copyright, which is all sorts of family photographs and ephemera, which technically has copyright protection. Even though publication is not the dividing line that it used to be, it's still extremely significant in copyright law. And I'll just illustrate a few of the examples. The US has copyright law with most nations on earth, but there are a few that are outside the fold. Iran and Afghanistan, no copyright relations. So if an Afghani publishes a work in Kabul, there's no copyright protection for it. But unpublished works are protected no matter where they're created in the universe. If somebody's writing an opera on the moon right now, that is protected under US copyright law. Even as to Americans, fair use is very significant in that it distinguishes between published and unpublished works. If you have unpublished email archives or letters that say the Diebold archive, fair use is much more difficult to establish as to an unpublished work than as to a published work. So that's another significance. It's mandatory to deposit published works in the Library of Congress. The term of protection for copyright, 70 years post-mortem auctoris. How do you know that an author has been dead for 70 years? You look at publication, and there is a presumption that if the work was published 95 years ago, that the author has been dead for 75 years, the work has expired. To maximize your rights under copyright, you need to register your works. You have a grace period from publication of 3 months within which to register the work. So there are dozens of effects of publication today. And the fact that publication has been so expanded is extremely significant for our investigation of the law of copyright. Well, skipping through the other faculties, let's go to the puzzle of dematerialization. We're going to start right off with the other main defense of copyright law. Besides fair use, there is the first sale doctrine. Let's illustrate the first sale doctrine. We'll look at a Supreme Court case that was handed down as well as a more recent district court case. The first sale doctrine poses a tension. On the left are rights belonging to the copyright owner. On the right are privileges belonging to users. If you have a copy of a book, you are allowed to distribute it. And there's a further wrinkle with the importation right, which we'll get to. I'm going to take us back in time to the beginning of the first sale doctrine. Here's the bestseller of 1904, The Castaway. Now, if you look at the copyright notice in 1904, it says that the price of the book is $1, and no one is licensed to sell it at a less price. So the shrink wrap, if you will, of 1904 says, thou shalt not resell this for less than $1. Well, you can guess what happened next. Naturally, Macy's went and sold The Castaway for a fraction of the price and was sued for copyright infringement. The Supreme Court said there is no restraint on alienation that attaches to the chattel, and so it rejected the cause of action for copyright infringement against Macy's for reselling this in violation of this erstwhile shrink wrap agreement. And that's been codified in the law at present. The law says that the owner of a particular copy is privileged to sell, give away, rent, or do whatever he or she wants with that copy. And that's why we have used bookstores in the United States, and that's why we have used record stores. That's why libraries in the United States do not need to pay royalties to copyright owners, unlike Canadian libraries, for example. Frey mentioned to me last night that one of his exercises is to send his students to Blockbuster. Blockbuster also exists because of the first sale doctrine, and at least until it went bankrupt. But that was not because of the copyright law. That was because of other considerations. And so I pose to you the question of the age, namely, who owns the paper or plastic? And I'm talking about the paper that is the substrate for the literary work, or the plastic that is the substrate also for the literary work. In the eyes of the Copyright Act, a novel and a computer software program are both literary works, and they're both embodied in a physical medium. And the question that the first sale doctrine asks is not who owns the copyright, but who owns the physical product. I don't think it's that evanescent a question, but if you understand it, you're doing better than the Ninth Circuit. Here's an illustration of the Ninth Circuit case. AutoCAD was a product that was sold to do design. So Cardwell Thomas Associates, an architectural firm, bought a copy of AutoCAD. The question is not licensing. If I read a book, I'm only licensed by the publisher. I don't own the copyright. But the first sale question is, do I own the paper? Here the question is, okay, of course, Cardwell Thomas is only licensed by the copyright owner. It does not own the copyright. But the question is, there's a little piece of plastic, polycarbonate plastic of a CD-ROM. Does it own that piece of polycarbonate plastic? Is it on the hook if it punches holes in it or uses it as a Frisbee? That's the question that's being posed. Ninth Circuit looked at the circumstances. It said, well, you bought a copy and it was called a license in the shrink wrap. And then later on, you, the architectural firm, upgraded your copy, and you paid a lesser price for the upgrade than you would have had to pay for a brand new set, and you're supposed to destroy the original. So, by the way, you breached your contract. But in any event, not only did they breach their contract, they went bankrupt. And so there was a sale of the physical product. That big box of AutoCAD 14 was sold. Along comes Mr. Werner, he buys it, and he offers it for sale on eBay. And he says, look, this is not loaded on any computer. this is my property. This is my physical personal property because I bought it from the previous owner of the physical personal property, namely Cardinal Thomas. The publisher files a notice for takedown. Werner responds by interposing his own lawsuit for declaratory relief, saying, no, I have every right to do this under the first sale doctrine. Now, the Ninth Circuit posed the question, sale or license. That's the wrong question. If the question is, who owns a book that I'm holding, the question is it sold or is it lent or rented to me? When I go to the library, I borrow a book. If I start punching holes in it, the library is going to get angry at me. On the other hand, if I buy a book at a bookstore and I decide to throw it in the river, that's perfectly fine. It should be the same question here for the physical product, the polycarbonate plastic. That was the CD-ROM. But the Ninth Circuit didn't look at that question. It said, oh, we're going to investigate the shrink wrapping. You know what it says? You may not lease or transfer the software with Autodesk's prior consent. Well, what's that like? You know what it's like to me? It's very much like the copyright notice in 1904 that says this is sold for $1. No one is licensed to sell it at a lesser price. But the Ninth Circuit evoked three bases for saying, no, there's no first sale defense here. The first is the shrink wrap specifies that the user is granted a license. Well, exactly like in 1904. Second is that license significantly restricts the user's ability to transfer the software. Wow. Again, that's exactly like 1904. And the third is that this license imposes notable use restrictions. So let's imagine that those notable use restrictions had been present in 1904. Let's say that the copyright notice I'm showing you, in addition, had said the following. You may not read chapter 3 until you have finished reading chapter 2. You may not read chapter 10 more than 4 times, and certainly not aloud to your friends. You may not write a book review about this book unless you get our advance permission. All of those are fair use, just like as number 4 is. It's fair use to engage in reverse engineering, but the copyright owner ratcheted up to itself unilateral rights and said, you may not engage in fair use. So let's just imagine that in 1904, the publisher had said the same thing. Does that mean the Supreme Court, which had said we're not going to countenance alienability restrictions on chattels, would have said, oh, but these are a lot of alienability restrictions, so we are going to enforce it? Well, that's evidently the logic that the Ninth Circuit used here in this case. So you might get the idea that I disagree with the holding of this case and find it inconsistent with old Supreme Court authority. But it's not only inconsistent with old Supreme Court authority, let's go to new Supreme Court authority. The copyright owner's distribution right also includes the right of importation. So now we have a question. Supap Kurtsang was an exchange student in Thailand. He found that because of price discrimination, you can buy the identical book in Bangkok for $30 that you'd have to pay $200 for in Durham. What I mean is, it's a book by an American in English with 15 chapters, American author, same book, same language, same chapters, published in the United States, published in Thailand. But the Thai edition has a legend on it. And the legend says, this copy for sale in Asia only may not be resold in the United States. Of course, Mr. Kurtzang did sell it in the United States. Publisher sued and said, you're in violation of our rights. So the Supreme Court construed the language. There are some very technical features of 602 and 109, which I won't get into. I have some problems with the majority's ruling, but I'm talking about the broad strokes here. According to the Supreme Court, the first sale doctrine triumphs here. And it was a ruling, not only did Wiley lose its lawsuit against the patent law firms, it also lost this case as well. So when I ask the question about Autodesk, that Ninth Circuit authority, I see it as not only inconsistent with 1904 law, but also with 2013 ruling by the Supreme Court. Now, one can imagine the Supreme Court reaching the opposite result. One would have to imagine that Wiley would alter its theory to say, we're not going to sue you for violation of the importation right. We're going to sue based on you opened up the shrink wrap in Bangkok and you entered into a license with us and you're only a licensee of the work and you didn't have the ownership of it. Therefore, you could not lawfully bring it into the United States. I suppose it's conceivable that the Supreme Court would have held in that direction. However, I have to tell you that from reading the opinion, None of the 9 justices of the court, not the majority, not the dissent, cared one whit for the legend that was on the book that says this book for sale in Asia only may not be reimported into the United States. So I find it very hard to believe. So I see this case as being wrongly decided on multiple bases. And let's imagine for a moment that the Ninth Circuit reads the 50 pages that I devoted to this case and decides to repent and say, we hereby unilaterally rule the opposite. We come up with the opposite ruling retroactively in Autodesk, and we will vindicate the first sale doctrine. Does that mean that copyright law is out of the woods and we can proceed along our merry way? Well, we have a further puzzle of dematerialization, and that is whether the first sale doctrine will survive the cloud. So far, it's only been litigated in one district court case. If you bought a vinyl record in 1970, you could resell it. If you bought an 8-track in, the vinyl would be 1950, the 8-track was in 1970, you could resell that. If you bought an audio CD in 1990, you could resell it for a fraction of the price. And so the question arises, if you spent 99 cents to download a track, can you resell it? And the answer on the first sale doctrine is yes. But the question is, can you resell it? What is the it? If I download onto my laptop here a number of works from iTunes, I may sell my laptop. The copyright owner may not restrain me from selling the laptop. But what if I like my laptop and I only want to sell the bits that I downloaded? Well, in that case, for a technical reason, the first sale doctrine does not apply. First of all, if one could simply lift the bits off my hard drive and put them onto your hard drive, that would be defensible. But that's not the way the technology works. The technology works by taking the bits from my hard drive, making a full copy on the remote purchaser's hard drive, and then erasing them from my hard drive, meaning that there's been an act of reproduction. The first sale doctrine only allows that particular copy to be sold. It does not allow a copy of that copy to be made and then the first copy to be erased. So this first ruling is that there is no first sale defense in the cloud. But let's imagine that not only does the Ninth Circuit reverse Autodesk, but that the Second Circuit reverses this case. Does that mean that the first sale doctrine will be vindicated in the context of the cloud? Well, we still have a lot to worry about. Let's imagine our world of pan-electronic access. Anytime you want to avail yourself of a work of authorship, you are going to go to the cloud. So unlike the 99 cents that you pay to download a track and put it on your hard drive, unlike the $9.99 that you pay to Amazon to download a book and to put it on your Kindle, a digital download, in this new world, if you want to read a book, Gravity's Rainbow, it's going to take you many hours, the publisher will charge you 4 cents a minute. And however long it takes you to read the book, that's how much you'll pay. If you want to watch the movie Avatar, the publisher will charge you $10 per hour. If you want to run an Excel spreadsheet, the publisher will charge you $2 for every quarter hour, whatever it is. The point is, there will be nothing resident on your computer. When the link is severed, when you log off, there will be nothing resident there for you to turn to residually. You'll just have to come right back and start again where you left off and pay another $10 for an hour's viewing or whatever figure I quoted, $2 for a minute of viewing. And that's because the first sale doctrine is limited to a particular copy, and there is no particular copy in the context of cloud computing. This is a very great puzzle for copyright law. I've talked about the beauty of copyright protection, and I've talked about the beauty of the safeguards that limit copyright protection. And the two that I've emphasized are fair use and first sale. So how does that apply in the context of the cloud? Well, to answer that question, I want to turn to the events of 16 years ago, when Congress enacted the Digital Millennium Copyright Act. There was a specter in the air, the specter of moving our nation towards a pay-per-use society. That is not a good thing. I'm quoting Senator John Ashcroft in this particular regard, but every senator, every representative, every Democrat, every Republican said the same thing. There was universal agreement. The Committee on Commerce felt compelled to address the risk that enactment of the bill could establish the legal framework that would inexorably create a pay-per-use society. And it guarded against that, unsuccessfully, but at least it tried. The chairman of the committee said that pay-per-view is profoundly antithetical to our long tradition. What about digital wrappers? Representative Dingell said it may sound like the American way, but it is not. U.S. copyright law historically has carved out important exceptions to the rights of copyright owners. And here's one more statement, and we could go on and on. So there was unanimity about this. In fact, there was more opposition to apple pie than to a pay-per-view world at the end of the day. So that's the DMCA. But the cloud, I've already showed you, does not have any first sale defense. It only has licenses. And what about fair use on the cloud? Well, there is no fair use. You have to pay $10 for every minute, every hour you're logged on, or $1, whatever the copyright owner wants to charge. You pay a fare. The chairman of the committee also praised libraries where people could access things for free. Okay, in the context of the cloud, there is no digital library where people can access things for free. So, what is the upshot here? Well, if Congress wishes to be true to its zeitgeist in 1998, it has a great dilemma. It has to promulgate entirely new strictures to allow user privileges when we no longer have the first sale doctrine and the fair use doctrine so automatically available to us. I testified before Congress on January 14th of this year, and my testimony was about the distribution right at the invitation of the committee. It was about a part of the distribution right called making available. But I highlighted this issue as something that is extremely confusing and that the committee should take up. And I volunteered to help the committee because at this moment I don't have the solution. But if the Congress wishes to retain fidelity to the proposition that was unanimous in 1998, then when copyright owners begin to do everything that I've said about their motion pictures and their software programs and their songs and their books, then the answer of Congress to those copyright owners has to be, well, the question is, what do we do in order to get to some resolution here? I've looked very much backwards in order to find the resolution, and something that I'm calling formalities over substance. Formalities are something that have been jettisoned from U.S. copyright law. 25 years ago, the United States joined the Berne Convention, and our Berne Convention Implementation Act eliminated formalities from U.S. copyright law, except that it didn't completely. Now, formalities can sometimes be extremely onerous. Here's the classic Italian movie, The Bicycle Thief, which was published in 1948, meaning 28 years later, 1976, it needed to be renewed in the records of the U.S. Copyright Office, or else it would go public domain. Happily, the Italians were not asleep. The licensee did come on a timely basis to Washington, D.C. and file a piece of paper. And you know what happened? The court ruled, the licensee filed the piece of paper. According to the technicalities, the licensor has to file the piece of paper. You're out. Copyright is dead. So there were all sorts of traps for the unwary. The copyright notice had to be in a certain place. It had to have certain words in it. And cases are legions in which the courts took glee in eliminating copyrights. Okay, that's not really what a mature copyright system should do. It should not promulgate formalities to randomly kill people because they don't know the intricacies of U.S. copyright law. But I mentioned that copyright formalities are not dead. The day before I got on the plane to fly here to Duke, I co-hosted the roundtable that the U.S. Copyright Office sponsored on recordation of transfers, which is a type of formality, which is every bit as vital now as it has always been. So formalities continue to be around us. One way that Congress could act would be to try to restore some of the balance that existed under the 1909 Act. So remember, it was only published works that were protected. Well, today everything can be published, which is why we have the dark matter of copyright. But Congress could take a look afresh at the issue. Congress could decide, we want to protect works of high authorship, but we don't necessarily wish to clothe pornography with copyright protection. There would be some thorny First Amendment issues to confront. It would require scrutiny, whether there is a legitimate government interest, and I'd love to join that debate in terms of whether there could be discrimination on that basis. So many copyright cases have been filing about multiple listing services. Is this something that Congress wishes to embrace within copyright protection? Simple ditties that people come up with at home, family photographs, should they be subject to copyright protection? Every email that you send. It's a fixed work. Should it be subject to copyright protection? Just in general, we could go through the range of works and say, copyright law is designed to incentivize authorship. Do kidnappers really need the incentive of copyright protection in order to come up with a ransom note? Okay, probably not. And throughout the realm of copyright, we can try to identify works that are not of high authorship and draw a distinction on that basis. But we can also invoke formalities. Now, at the time that the fathers of the Berne Convention convened, formalities were a bad thing. First of all, if you were Belgian, you had no protection in France. Okay, the Berne Convention managed to solve that. Second, if you had to go from Spain to look at the copyright records in Ottawa, Canada, or Canberra, Australia, as of 1905 or 1935 or even 1965, that would have been terribly onerous. Today, we don't have that same disability. We have the possibility of registration on a wide-scale basis. And so as we unwind through history, I want to talk about revision of the Berne Convention to accommodate the world of the internet. Now, there's only been one diplomatic conference that was convened for that purpose. I happen to have been present as the representative of MCI, AT&T, Verizon, AOL, and a host of tech companies. My job was mainly to give press conferences at the Intercontinental Hotel because nobody else wanted to listen to me. But I had a good idea that not even my clients wished to hear. And the good idea was the following. You know what? We're gathered here in Geneva to revise the Berne Convention, which comes from 1886. Berne Convention is based on national treatment. It's based on a very archaic notion that really doesn't fit what we're here to do, which is to come up with the rules of cyberspace, which is not localized. In fact, I remember Jerry. I remember you and I spending a lot of time talking. I think maybe you were listening to me. I hope. Okay, so I thought it was a good idea until the first vote was held. And then I realized I was just spitting in the wind. The first vote was the following. The EU delegate made a motion, a procedural motion, saying, I represent 12 member states. I should be clothed with 12 votes. Japan went ballistic, said, I only get 1 vote. Why should you get 12 votes? The US brokered a compromise. The compromise was as follows. Yes, EU delegate, you will be able to cast 12 block votes, but only at such moments as all 12 national delegates are sitting in the conference room. I couldn't believe it. Here we are trying to make the rules of cyberspace, which is the rules of no space, and the most important thing is you have to be within eyeshot of me or else you don't exist. So I gave up then, and I'd be happy to come back to it. But at the moment, I have a more modest proposal, which is to reinstitute formalities. There have been some scholarly articles about it. A recent conference at Berkeley took place on the subject. How would we do it? Well, they're low cost. There's all sorts of benefits that come with it. We have to have data, and we have to have works that are provided. It's already beginning to happen in a small way. Last week, the multi-billion-dollar litigation that Viacom brought against YouTube was settled. And part of the settlement had to do with filtering in order to find copyrightable works. So my immodest proposal only has 2 propositions in it. First, we establish a panopticon, and everything that's on the panopticon will get great enforceability, and everything that's not there will get limited enforceability. What is the panopticon? Well, it goes back to an idea that was promulgated as part of prison management, actually. But the participatory panopticon refers to making a comprehensive database of all human activity available. And those sources that I've indicated have started the process. How do you identify something for the panopticon? Well, we already looked at the Google book search. The Google book search needs to be put on steroids. It has to include not only books, but sculptures and songs and architecture, novels, the Journal of Catalysis and everything else that was the subject of that patent case, et cetera, et cetera. But it shouldn't be the Google book search. It should be something beyond that, perhaps the Library of Congress search or perhaps the United Nations search, the World Intellectual Property search. If we have one central registry and it's located in Johannesburg, it's not difficult the way it was in 1930 to go to Australia. It's very easy to use the internet to look at this panopticon plagiarism machine. Now, what is this machine? It's really nothing other than the Turnitin machine on steroids. Instead of having those term papers, it has everything in it. But obviously, it has to be implemented in the manner of the Patent and Trademark Office, not in the manner of the Second Circuit. In other words, it's not there to make everything published and everything available. It's there to do a search. And once that search is facilitated, it's going to benefit both putative defendants and putative plaintiffs in copyright infringement cases. Here's some testimony earlier this month to Congress by a Grammy-winning artist who talks about content identification. She says, just like there's a do not call list, there should be a do not upload list. Well, with the Panopticon, that could theoretically be possible. So it benefits defendants in the sense that if I'm putting something out and I don't want to be sued for copyright infringement, I don't have to worry about being blindsided about something whose existence I know nothing about. I search the Panopticon and I know about it. If I'm a putative plaintiff, I'm benefited because I put my work in there and I'm going to get full relief. What about treaty obligations? Is the U.S. under an obligation not to have those formalities to the extent that I'm proposing? Well, the only mandate of the Berne Convention is that infringing copies must be liable to seizure, and the TRIPS Convention adds you have to have effective enforcement. It also adds there has to be procedures that are fair and equitable and not unnecessarily complicated or costly. I know many district court judges who are walking violations of the TRIPS protocol, but that's a problem that copyright law cannot redress. So identifying the legislation to implement this would be very simple. Either you include your work in the Panopticon, which could be automatic when you upload it to the internet. It could be automatic when you publish a book. Or you can decline to register the work, in which case you will simply get reasonable compensation. Namely, your out-of-pocket loss, which is not terribly palatable for filing a lawsuit. Well, as I've looked at the curiosities, I'm delighted to be in North Carolina because right there on the Outer Banks, before the 1909 Act was adopted, we had the new technological innovation that set us forth on our modern era. And I've tried to illustrate for you some of where we can head in Infringement 2.0. Thank you.
Professor Nimmer has agreed to take some questions. We have 5 minutes. We'll start with the student and then we'll
Student, come on.
Okay.
Wonderful lecture, David. I want to ask the why question. You're absolutely right, I think, about almost everything you said. But the why question about licensing. The backstory to this is that the courts had to deal with software being thrown into the copyright box with potentially devastating consequences to the software industry. Many people, including Jerry and myself, prophesied it would be a disaster. And the courts, I think, did a brilliant job in sort of trimming and retrofitting copyright law, by and large, so that it didn't destroy software. Preserving interoperability, using fair use, using all the common law techniques. And then they come to licensing and they do what is effectively a 180-degree turn and really put in the seeds of completely undermining everything else that they've already done. My fear is that the students in this room will get the question from their children, Daddy, was there ever a time when people owned their books? That will actually be inconceivable to the world of the future. So why, given all this background, did the courts get it so wrong?
Okay, I think the answer of why the courts got it wrong is that what I said about software being a literary work. In 1980, the decision was made to clothe software with some protection and, faute de mieux, copyright protection. What within copyright? Well, I don't know. It has numbers and letters. That's kind of like a book, which has numbers and letters. So we'll call it a literary work. And that's fine because all of copyright law is made around literary works, namely books. So it won't be a big dislocation. Then fast forward 25 years. What if all the litigation is about software and not about books? If you have the same legal regime, then what's decided about software will determine what you can do for books. So the Ninth Circuit made a choice that I think is perfectly reasonable, writing on a blank slate as a policy matter, saying, you know what, books should be resold, but we don't think that software should be resold. There's a different economic package that's there. And we like to foster price discrimination. We want to tell you, Autodesk, sell your student copy for $30. Sell the advanced copy for $100 and sell the architectural copy for $500. Great. Problem is that the U.S. Supreme Court talked about price discrimination in the Kurtzsang case and said, this will ruin price discrimination. Good. So we need to have a new legal regime. And I testified to Congress about that too. And I talked about this case and I said, look, maybe Congress wishes to divide up the first sale doctrine. One should apply to traditional works, and then there should be a different first sale doctrine that applies to computer software. That would be a coherent way of proceeding. So the problem is in 1980. Yeah, good.
So there's been some talk about how Content ID isn't doing a good job with the transformative use. So if you have even more to get the panopticon, then how do you sort of balance those two things?
Okay, good. Okay, thank you, TG. Good question. I was talking about slavish copying at the moment. We could have other levies in place for user content. So, for instance, Girl Talk does a mashup. It has some elements that are taken from other works, and yet it's original in its own right. Perhaps there should be a levy that Girl Talk will pay. Used to be you would pay 2 cents a record in 1909 to produce a mechanical recording, and over the century that has elevated until today it's 14 cents per record. Could be to make a mashup. It would be 14 cents per record divided among all the people who are sampled. So what I presented today, I didn't have time to get into everything, and there need to be refinements along the lines you suggest.
Wonderful talk. As we have you here, a question dear to my heart. Is there any possibility that we will actually adopt the making available right that we were supposed to get out of the WCT?
Well, if Congress listens to my testimony on January 14th, then it's quite possible. But, you know, this raises the bigger question. When will the new amendment come into effect? And I told Jamie this, and I'm actually going to do it. I'm going to make a website that everyone can participate in. We're going to have a pool as to when the next Copyright Act will be adopted. Right now, I'm reserving May 25th, 2029 for myself. But whoever hits the date will get the big prize.
$1 billion.
Yeah, $1 billion, that's right. The dean has offered it.
All right, well, let's hold it there. Thank you very much. That was wonderful.
Good.